Professor Foner, let me begin with you. This case is going to the Supreme Court. We have all watched the Supreme Court justices and their clerks eagerly play amateur historian when faced with these questions. When they dig into the 14th Amendment, Section 3, what should they find?
Well, I think, as Judge Ludig said, the language is pretty clear that any person who took an oath of office to the United States and then engaged in insurrection, rebellion, is disqualified from office of all kinds, president and all the way down. I think they will find that this was put into the Constitution in order to prevent ex-Confederates from gaining power again after the Civil War, particularly in the southern states. In the debates at that time, they were less interested in the presidency, because you can always impeach a president if you want to. But they wanted to try to make sure that the southern states, if they were brought back into the Union after the Civil War was over, would be governed by people who accepted the results of the war, the end of slavery, equal citizenship for African Americans. That's what they're trying to do, to step into the states and make sure that the good people, as they saw it, were in charge in the southern states.
Professor Blight, as you look at it, what would you expect the Supreme Court to focus on if they were seeing this from a historian's perspective?
Well, I would hope they look at two segments of history. Eric just pointed us to one of them. They need to really read those debates in 1866 over the creation of the 14th Amendment. But I would guess they're also going to be looking, if not explicitly, implicitly, at Bush v. Gore. I mean, to me, this Colorado decision, it seems to me, is going to depend on whether there are 5 justices who will be good textualists and do as Lutic said, read it carefully and do what it says, or whether they are truly going to be haunted by Bush v. Gore, which was their step into determining who wins elections, and determined somehow to never do that again. Only one member of this court was there in Bush v. Gore, of course, and that's Clarence Thomas. Now, I doubt he's going to be haunted by it, but I really think that's part of what they're going to have to look at. And I today just went and read the case, or some of the case, and I read Justice John Paul Stevens's incredible and unforgettable dissent, where he predicted that the greatest winner of that case would be cynicism in the American people in not trusting judges in the future. I hope they go and read John Paul Stevens's dissent in Bush v. Gore.
Andrew Weissmann, what was Judge Ludig talking about there when he said the Supreme Court will try to find a way to somehow dispose of this case without ruling on these central meanings of the 14th Amendment?
So this is what lawyers do. They take something that's seemingly simple and make it complicated. So issues that the court can deal with: what's the definition of insurrection or rebellion? What's the definition of engage or comfort or aiding? What's the standard of proof? Who decides it? Something that Professor Foner referred to. Is the president of the United States encompassed within this? As you know, Donald Trump says that no, it's not. It'd be interesting to know what the historical view is of that. And then there's some state law issues which are sort of complicated for the court to reach into, because those are supposed to be independent and state court grounds that under federalism the Supreme Court doesn't reach into. But there are some issues there that I'm sure Donald Trump will raise and try to get the Supreme Court interested in as to whether this is procedurally done correctly. So there are lots of, as Judge Ludig said, off-ramps. All of those, by the way, except for maybe this issue of an officer, are ones that could lead to further fact-finding by the Colorado trial judge. In other words, if the court says the standard of proof was wrong, or we need you to find the following definition of insurrection, that just can go back to the trial court for further findings. So, it's not clear exactly how the Supreme Court's going to do this to get an off-ramp that gets this completely sort of done with and gone for all purposes.
Professor Foner, can you help the Supreme Court define the word officer in Section 3 and the word insurrection?
No, they will have to decide that for themselves. There is no precedent, really. I mean, David Blight pointed out that Bush v. Gore is pretty close, but there's no precedent for a presidential candidate being disqualified for office for reasons like this. So there is no existing definition in the jurisprudence that would directly relate to this case. But remember, in the election of 1876, soon after the 14th Amendment, Supreme Court justices were involved in choosing the president then also in a electoral commission that was established, including 5 members of the Supreme Court in a disputed presidential election. So judges may very well like the idea that they can choose the president. They don't get a chance to do that very often. So I'm not so sure that they're that anxious to have an off-ramp, unlike my colleagues here.